Welcome to our April Evidence-Based Services Committee Roundtable. I'll have the pleasure of introducing our special guest presenters in a minute, but some housekeeping announcements first. Whichever email you use to register for today's roundtable, please be on the lookout for a feedback survey that we'll be sending to you at that email address. We would greatly appreciate it if you could fill out the forthcoming survey to give us feedback on the quality of today's webinar. We would like to say thank you to the Hawaii Psychological Association, HPA, and the Hawaii Behavioral Health Connection, who are co-sponsoring this roundtable presentation and offering free continuing education credit or units for its HPA members and volunteers. If you have signed up to receive psychologist CEUs, the CEUs will be awarded based on your time in today's webinar, and you'll be expected to attend at least 90% of today's roundtable to be considered in the awarding of CEUs. Moving on to introductions, our two keynote presenters, Katie Bennett and Jessica Summersgill. Katie is a family mediator, social worker, lawyer, educator, and child advocate with over 20 years of experience settling and litigating cases in the areas of divorce, paternity, guardianship, adoption, and child welfare. In 2019, she started Family Mediation Hawaii, a firm committed to supporting better outcomes for families by providing alternatives to litigation. Welcome, and thank you very much, Katie.
Thank you.
Jessica Summersgill is a trained mediator, family law attorney, parenting coordinator, and advocate for children who values collaborative work to support families. She's admitted to the Hawaii, New York, and New Jersey State Bar Association and is a member of several law sections, including family law and child law. After clerking for the Honorable Kathy L. Wasserman, I don't know if I'm saying that right, sorry, and practicing family law litigation, she spent 5 years advocating for children as a guardian ad litem in contested custody cases. Jessica continually updates her training through the Association of Family and Conciliation Courts and volunteers as a mediator with the Mediation Center of the Pacific. She is committed to empowering families to act in their children's best interests. Andrew, am I missing any other announcements about the chat or anything?
No, I think we're good to start. Yeah, those are just the CUs and then the introduction, and then yeah, Susan's introduction will be later after the presentation.
Okay. Thank you. Sounds great. So without further ado, turning it to our key presenters for today. Thank you very much.
Thank you so much. I'm going to let Jess start and then I'll launch into learning outcomes, but I appreciate the introduction.
Yeah, thank you so much for having us. That was a lovely overview of what it is that we do. Our background is as family attorneys, but we work a lot with families, court-involved families, or ones who are going through a separation, divorce, custody concerns. So we support families in that space. And at Family Mediation Hawaii, we try to stay up on training and work a lot with mental health professionals, professionals who have expertise in child development, so that our work is informed by those areas of study. And I hope that what we share about maybe what we do is relevant to what you do, and maybe we can learn something from one another. But thank you so much for having us. I'm very grateful to be here.
Thank you as well. We really appreciate this opportunity to sort of cross-pollinate with other professions. We know a lot of you are doing the day-to-day heavy work with children and families. And I think it's interesting to hear about, what other folks do. Right out of the gate, I started at legal aid. So I was a guardian ad litem for kids in foster care. But I also went back to school at night at the University of Hawaii School of Social Work and got my MSW because I realized very quickly that my clients didn't really need motions in litigation. They needed childcare and food and housing. And so, it's been sort of an evolution. I spent a long time in private practice litigating cases, had my second kid realized it was just too much. Like litigation is really hard on families and it's hard on the litigators. I moved into the School of Social Work, teaching history and policy, had my third kid over there, and was lucky enough to have the opportunity to volunteer at the Mediation Center of the Pacific. For those of you that don't know, Tracy Wilkin is amazing. She does excellent trainings. The training she does for mediation, I think is just as good as I've been to, AFCC and Pepperdine and all these trainings on the continent. I think what they do at MCP is really excellent. I had the opportunity to volunteer and just started working with kids and families, mostly their parents, right? Kids don't have problems, they have parents, on how do we navigate these difficult transitions in ways that are not super unhealthy, right? I think as a society, we sort of made this decision that divorce is a legal issue and therefore we litigate and we have, adversaries who are zealous advocates on behalf of parents. Frankly, that throws gasoline on the fire sometimes. It's not the healing and the help that we really want to bring to families. So in that vein, I'm going to start with our learning outcomes. I'm not going to read them to you. You guys are all really good at this, but we're going to just try to bring research, best practice. How do we help these court-involved families navigate and help you guys as professionals working with a lot of them understand what are the alternatives to litigation and how can we help support families as they create a new normal, which is oftentimes living from two separate households. We want to be a resource to you, right? We want this to be a relationship where you can reach out to us. If you've got questions, we're definitely going to leave time for question and answer at the end, but in the midst of this, if you want to, please do put questions in the Q&A. Normally we have sort of a live audience that we can poll and ask questions and it gets really fun and interesting. But, I think we're just gonna have to save it till the end, but we're happy to entertain questions. And Jess, I'm gonna let you go ahead and start talking about the meat of this, which is conflict hurts kids.
Yeah. So giving you context, which I'm sure will already sound, quite familiar, historically, practitioners believed that divorce itself was harmful to kids. The research that they did showed this link to children having issues down the road, whether it be behavioral or substance abuse or depression or anxiety. It was higher in children who had gone through a divorce. Now, as the research got more in-depth, more detailed, a little bit more informed, they realized that the divorce in and of itself, living between two homes, is not the harm. It's high conflict that they were exposed to that was the harm, right? So really we want to take, as time has gone on, the stigma around divorce has, gone down, and there are all sorts of structures to families, but it's the ongoing conflict. It's the exposure to fights. It's the litigation that gets ugly and lasts for years and drags out, the intense adversarial positions of the parents that harms the kids. So what we have learned is that there's better ways to do it. There's better ways to support the family that hopefully keep that conflict level low and allow the children to thrive no matter what their family structure looks like.
Okay, and so there's been a lot written about domestic violence and mediation, and historically, we would say it's not appropriate, right? Mediators have no power. They can't make decisions. They can't order people to do anything. And so if you have a power imbalance, they were saying, mediation is not appropriate. Now, the research has evolved. And what we've found is that litigation is not a great process either, right? And while it is difficult to handle power imbalances in mediation, and that's not just violence or psychological abuse, it can also be a nursing mom who doesn't want dad to have time with the baby. Or it can be the person who has all of the financial information, knows where all the money is. The other person doesn't know. There's a power imbalance. And so, as neutrals in a mediation, our job is to try to manage that while at the same time staying neutral. So we are constantly checking ourselves to make sure, we are not perpetuating a process that's going to, make a survivor feel like they're being, like there's further abuse. But what we found from the research is that if you have a skillful mediator who can, we can create a process that keeps people safe. Now with Zoom, before it used to be like, okay, we'll let the survivor go first and make sure that they're out of the parking garage before we let or we keep them in separate rooms the whole time. There's ways to do this. You can have a support person involved, but there are ways to keep mediation, to have mediation be safe. And the bottom line is that if survivors feel comfortable and they want to try mediation, we don't want to shut them out of a process that's going to take less time, cost less money, and give them the self-determination to make their own decisions as opposed to giving it to a judge. We do know that mediation should not, we still don't impose it on people if they don't want to do it. In fact, not just on the survivor, on either part. Mediation is supposed to be a voluntary process. There was research back in 2008, an article in the Family Court Review by Joan Kelly and Michael Johnson. We can send it to you if you want, but we really start to evolve in the way we thought about intimate partner violence and differentiation in the different types of violence, right? If it's situational violence and it's a one-time, I want a divorce, someone punches a wall or throws a cell phone, that is very different, what we found, than like coercive, controlling violence. And in those cases, we do, and at our firm, at Family Mediation Hawaii, we have implemented a systemic screening. So we screen all of our cases because the reality is a lot of times no one says anything, and there has been violence and there has been coercive control, but no one says anything. And so we really can't ever know. But we can try to keep this process as safe as possible, and try to maintain neutrality throughout.
So some of these terms will look familiar to you. There has been an evolution as we've gotten better with language being updated. So the old term that you're probably familiar with is legal custody, which still exists today, but we really refer to it as decision-making authority, right? That's what it is to parents. Those are the big decisions that relate to the child's health care, education, where they go to school, their religion, their practices in that sphere. So that's where we are, coming up with an agreement when it comes to legal custody or decision making. There's no presumption of joint legal custody or sole legal custody. There's no presumption at all. It should just be what works for that family. I think it's most common to have both parents share decision-making authority, but it's not a legal presumption. Now, the next term is physical custody. That's really where the child spends their time. So, or who a visitor to their children. They are both spending time with children as parents. And so it's just a matter of figuring out parenting time. And the term physical custody, really think of it as a sliding scale. One parent may have all the parenting time, and we might refer that, in a way that's they have physical custody. So that would be an exception to this kind of joint physical custody. But then joint physical custody can be so flexible, right? That's the schedule that you come up with that really suits the family. So it could be based on their work schedules. It could be based on how closely they live together, right? So many things come into play when you're crafting a parenting plan. And you really want the research supports sharing time with both parents so that they each have a meaningful relationship with the kids. And we always remind our own clients, sometimes it's quality, not quantity. So it's not about keeping score and making things perfect and, keeping track of my minutes versus the other parent's minutes. But it's really, are you having frequent, meaningful, contact with your child? Are you building bonds with your child? Is that time together, just maximized in terms of how you are building the relationship? So that's where we get into building those beautiful parenting plans that we do that have to do with their week-to-week schedule, their holiday schedule, etc. Now, in very high conflict families, you'll also hear this term parallel parenting. Really what that does is it gives the most amount of buffer between the two parents so that other than communicating about the really important stuff, safety issues and education, they let the other parent have their parenting time without a lot of crossover. So you do your house, I do my house, and there's not much in between. So those are some terms you may hear. Just know that really it's about decision making and where the child spends time, and that's how we frame it for our clients.
Yeah, I mean, a lot of parents, and you guys know this, right? They get so stuck on the labels. I want joint custody. I deserve equal rights and equal time. And part of that is because our laws and our policy, right? Child support is calculated based on the number of overnights. And so it does cause people to fight more. And sometimes that's something that we as policymakers can influence. And when I am on the Child Support Guidelines Committee, and we're trying to make changes that will help people make it easier for people to agree, because again, it's the conflict that hurts the kids, and that's what we want to prevent. Um, let's see. So things have changed over time, and Jess kind of talked about this, but we used to have, when I first started practice in 2005, we had type A and type B, and type A was every other weekend and a Wednesday night overnight, right? And it was usually the dads that got the every other weekend and the Wednesday night overnight. But now as we evolve, we realize that while equal time sharing isn't perfect either, shared custody, which is defined as sort of that maybe 25 to 30% with at least with the child who with the parent who has less time, um up to 50-50, exactly 50-50. And we do have those parents that are going to count every overnight and split every spring break and every Monday holiday they want accounted for. And we can do that in a parenting plan. And that's one of the nice things about mediation, is because we can adjust, it's not a cudgel, it's a scalpel. What does this particular family need? I've done parenting plans for people who want to celebrate like the winter and summer solstice and fall equinox. I've done parenting plans for various, different things mean different things to different families, and every family is unique. And so we can help with that. The same is true with decision making and legal custody decisions, right? I mean, sometimes you can give tie-breaking authority. You can have one parent in charge of medical and the other in charge of education related. So we can really kind of be creative about what makes sense for each individual family. Again, this is sort of historical, right? Fathers used to own the children. There was a paternal preference back in the day. Then we moved to the tender years presumption, which is now no longer part of the law, but it used to be if a child was 3 or younger, they thought mom should have custody. We definitely see, although we don't have an equal time sharing presumption in the family court, other states do, but we've definitely seen more and more fighting about trying to get equal time. People always ask us, when can my kid choose? Right. And we always tell them kids should have a voice, but not a choice. We don't want kids to be put in the middle and asked to choose. Hawaii does not have a set age at which point a child can choose. It's dependent upon the child's age and their developmental space. So it's not, it's a lot. We don't want kids to have to pick parents, and it's really, really hard on them. That's one of the things we educate parents that we work with about.
Yeah, so here's some interesting research that came out not that long ago. The efficacy of shared parenting, which we kind of defined based on this study of 25 to 30% or more, has been supported as long as the children are of preschool age or older. Katie touched on this a little bit, but babies and toddlers sometimes have a little bit more exception, have different needs physically or emotionally than older kids. But shared parenting benefits kids because they have this, the resource of both parents, the relationship of both parents, right? But it does not necessarily mean equal parenting time. It means meaningful parenting time with both parents. It means good relationships with both parents, but it does not necessarily mean equal. So really, this is going to be all about, are the parents physically and emotionally available, and how do we make the schedule work? Now, this is the best outcome if the parents are safe and protective, right? This is meant for parents who are ready and able to parent. And really, the system is quite flexible. There's no legal presumption of joint physical custody. So we can now tailor it to the family's needs. I love to ask curious questions about what the schedule looks like now. How do you think it could be better? We get into details. We talk about really, work, school, after school, holidays. We get all into that stuff. And really what you're looking for are parents who are willing to collaborate and meet the children's needs. Who's going to handle this pickup? Who's going to handle that drop off? How do the exchanges happen? And we try to take into account in every decision what is in that child's best interest. So we want the parents to be, like Katie said, the decision makers. We're not putting it on the kids. We are going to reassure the kids that the parents are going to come up with a plan, and then we're going to clearly communicate that to you. And that's how we're really going to center around the kids and all of these decision-making steps along the way.
Okay, I sort of alluded to this before, and I think a lot of you probably understand this, but the traditional adversarial legal system is probably not an appropriate place for families to resolve as they transition. Prior to 1980, only 1 in 10 marriages ended in divorce. Now we're closer to hovering around 50%. It's not quite 50%, but a lot of these families are finding themselves needing to sort of transition midway. And we try to remind parents, you're not adversaries. You have shared interests in not screwing up your kids with a horrible, ugly divorce that can last years. Not spending all your money on lawyers and litigation and discovery and all of the things that go along with that whole process, going out to Kapolei Family Court. Our judges are wonderful human beings. They try really hard. They don't have enough time to hear all the evidence. And the rules of evidence, frankly, are going to say that certain things don't get heard. So, you got to be really careful when you give up control over your life and let this person, we say, the person in the black muumuu who doesn't love your kids, doesn't know you, is going to just hear little snippets of testimony, make really important decisions for your life. We also do see lawyers sometimes misusing or misunderstanding the social science research. Because they're so focused on the adversarial litigation process and how do you win, right? And it's not a win or a lose. This is an ongoing process. Families are going to have to survive their lives going forward, and it's a lot. I really would love it if we could reconfigure and have more mental health professionals in this space working with families. People always say, well, non-lawyers shouldn't give legal advice. Well, I don't think lawyers should give parenting advice, frankly, unless they, know something about it. Okay, what else am I saying? The conflict is even, and so we see these really like high level, the issues we see a lot are very young children, because it's just said, like, and the thing to remember about parenting, and this is why it's so hard, kids are always changing and growing. So your parenting plan is a snapshot. We want people to work together and be able to agree on things in the future. We always say we're trying to work ourselves out of a job, but we do get pretty detailed in those parenting plans because we want it to be a fallback, because again, the goal here is to reduce conflict in the future so that the kids don't have to be exposed to that. But if one of the parents, and I'm sure many of you, are subpar parents is what the judges will call them, where they're not able to put their kids' needs ahead of their own, or they have severe mental health issues or challenges with substance abuse and other issues that make them probably not the best parent. Those are tricky situations, and we have to balance. Do we want, yes, it's good for kids to have two parents in their lives. We do know that. But if it's, that we also want to make sure that there's positive quality co-parenting. Yeah, I'm gonna stop there and let Jess talk more about these things.
Well, I was going to say too, on that slide with litigation too, when parents are going through a divorce proceeding, we're also dealing with property division, money issues. Custody is one part of that, but there's so many reasons it gets adversarial. And we try at least, Katie and I think that numbers and money is like one issue that we can try to make fair, right? Or like we try to find what's equitable for both parents. Custody, it's not really about what's fair to the parents. So it's a shift for them to wrap their brain around, like, I want what's fair and what's mine when it comes to property or money. But when it's about kids, it's just about kids. So it's not about what's fair to the parent. And so, yeah, based on, how things escalate, that is certainly understandable. They're really pitted against one another, like Katie said, a winner or a loser, or trying to, posture or get the best outcome. But when you are going through either a separation or a divorce, you have to maintain some workable relationship, you hope, because you have to stay on as co-parents. You don't get to, win or walk away, right? You have to be amicable enough to raise a little human together if you're, in this custody sphere, right? This co-parenting sphere. So yes, I think that that's really, really, it's not the best space for families, because it does set you up with all these, tricky issues. And then at the end of it, you have to work together. So better
And they keep fighting, right? I mean, we have post-decree cases where they're already divorced, but they can keep fighting about things.
Yes.
And so the law allows for that. And so it can be, if people are really bitter, and again, remember, these are folks who were if they were married, they loved each other. I mean, even if they, sometimes we have the like one night stand babies and now we have the parentage act, so we don't call it paternity anymore. That's a whole nother hour and a half training. We're not going to go there. But we see these because we see so many families and we mediate we mediate property division, spousal support, and all the child related issues, including decision making, parenting time, and support of the children. So we get into the weeds for sure. But the problems that we see over and over and these sort of red flags. So we used to talk about, and it's gotten into the domestic violence space as well, because there is alienation, right? Where one parent says negative things about the other parent to the child versus the other side of the spectrum, which is justified rejection, where, hey, you see your mom try to run over your dad with a car, you're going to be kind of scared of mom. Maybe you don't want to go over there. And there's been a lot of back and forth. They called it resist, refuse for a time. Now the most updated nomenclature is parent-child contact problems, because the reality is sometimes we don't know if a child is refusing to spend time with a parent. It can be a very complicated systemic issue. In fact, I think they're working at family court to try to address these issues because they're seeing these cases more and more with kiddos like 10, 11, 12-year-olds who are just refusing time with one parent. And we really need family therapists who are willing to get in there and roll up their sleeves and work with the family, because the court system doesn't know what to do. They don't know how to handle these. You know, we try to educate parents that it's really important for children's self-esteem, that unless the other parent really is truly dangerous or there are real safety issues, it's good for kids to have two parents and have them both involved. The other space I alluded to before is with those very young kids, 0 to 3, 0 to 5, those schedules need to change over time. Obviously little infants, we're not going to do week on, week off. We just don't, we know that's not healthy. We want to promote healthy attachment. We want to make sure kids have what they need first and foremost. But they are tricky to create these sort of parenting schedules for now and then transition them to longer, larger periods of time. Some people want to set it to like starting June 1st, here's the new schedule. Other people want to say, well, let's see how the kid does and let's assess. Both are valid ways to do things if we're trying to reduce conflict, but it's not clear when overnight should begin. The experts don't agree. I think there's some evidence that if parents live together in a shared household, it's probably easier for infants to do overnight sooner if parents can communicate and talk with each other. Again, infants can handle, can do better in those situations, but there's no like, oh, at age 3, we're going to start overnights. That doesn't exist. And then, of course, shared parenting in the context of prior or current family violence is definitely a red flag. When we have those kind of coercive, controlling violence dynamics, we got to be really careful in these situations because we don't want to cause harm. Jess, is there anything else you wanted to say about that before we move on to the statute?
Well, on this slide, that parent contact problem you were talking about, that's when we almost always overlap with mental health, professionals. That's when we have family therapists, individual therapists, hopefully a team involved in supporting, because often parents need support through that, children need support through that. Giving maybe some feedback to the mediator or the parents as to what's best in terms of the outcome and the pace. And I think in cases like some of these, when there's maybe alienation or we just in the broader term, the contact problems, that's when we really work very much in tandem with professionals in healing that family versus having legal, authority to solve that problem. That's kind of, they have to work in teams. So that's a really, I think, developing area of what we're trying to learn more about and come up with best practices for, because some of these are very challenging. What we do is fair, somewhat straightforward if, we have typical cooperative, family, easygoing kids, but that's not always the case. And so how do we support the ones who are having a much harder time with the transition or the changes? And hopefully that's where we overlap with people who do maybe more of what you guys do. And then this may be just more informational for you, a bit of light reading if you're ever curious. But these are the legal statutes, the laws that dictate how these decisions are made if they are made in court, right? So this is all of the step-by-step procedure, the definitions. If you're ever curious, you can go look it up. But we have divorce and paternity or parentage. We have the protective orders under the TRO, temporary restraining orders. Child custody is the one I'll talk about in a little bit more detail. That's the standards and the what did we criteria that we use when we're making decisions about parenting time and custody. And then, of course, there's guardianships and adoptions and the child welfare space as well. But these are, yeah, our guideposts as we study the legal side. This is that statute we were talking about called the best interest of the child. So if a judge is to make any determination on custody, this is their guiding star. These are the 16 factors that are considered when making that determination. Now, there's no procedure as to what is more important. It's basically a balancing act of considering all of these different factors as they apply to the family. Not all of these will apply in every case, but in my past life, when I wrote reports as a custody evaluator or a BIF or guardian ad litem, this is where we would do the analysis as to what was in the child's best interest. If you can imagine breaking it down into, legal criteria, this is the best they have been able to come up with when it comes to meeting the child's needs. Now, something I will often point out to parents, so, the ones on here are the physical and emotional needs of the child, the history of caregiving between the two parents, the educational needs of the child, relationship with siblings. Like, a lot of these make sense. Some of this is about the parent's ability to prioritize the child's needs or support the child's relationship with the other parent's family, like allowing them to attend events, with grandparents. Of course, there is the issue of substance abuse and mental health of the parents. That's always a consideration, or if there has been any form of abuse, that's a consideration. But think really all broad spectrum, what is in the child's best interest. One of the things I point out to parents is that no factor on here is what is fair to the parent, right? These are all centered on the needs of the children. So whenever that parent is kind of coming at me with like, well, I'm entitled to, or it's my right to have, or that's not fair, gentle reminder, that's actually not the, decision that, that's not the criteria we're going to use when we make these kind of decisions. So this is, again, some just window into how the courts approach these things when it comes to parenting time and structuring time with children.
Okay, so for you folks as mental health practitioners, there are a lot of pitfalls, unfortunately. And I've talked to a lot of folks who say, you know what, we just don't want to work with litigating families because I don't want to be subpoenaed. I don't want to have to testify. And that's really unfortunate for the families because they need you, right? And it's what we try to do, what we've talked to the judges about is how do we protect our mental health clinicians, which is different than like a forensic mental health. So like a forensic person, I don't know, you guys all probably know Marvin Acklin. He's like been doing this forever. He's a custody evaluator. He's a forensic, right? His client is the court. And he's used to getting up on stand and testifying and justifying his expert opinion. But for those of you that are engaged as clinicians, whether as an individual parents therapist, a couples therapist, a co-parenting therapist, the child therapist, or the family therapist, that's a little bit trickier because there's privileges issues, there's confidentiality. We had case law coming out. Oh, when did PO versus JS come out? I'm going to get it wrong if I try to give you the date, but I can send you the case. But it basically said that if parents are fighting, neither of them can waive the child's privilege. This was a case where I think it was Rob Welch was the therapist, and mom wanted him to testify, dad didn't want him to testify. And what the ICA said was, if parents can't agree on whether or not to waive privilege and whether that's in the best interest of the child, the court should assess and essentially appoint a guardian ad litem to represent the child's best interest to go and do an investigation and then assess whether or not it's in the child's best interest for that privilege to be waived. So going back and talking about those forensic folks, they include guardians ad litem, If you're not familiar with parenting coordinators, they're essentially referees, almost like arbitrators who can make small decisions about the kids. And they're for high conflict families. That process came out of AFCC fairly recently in the last 20 years. But really, it's about how do we give more support to these high conflict families so they don't keep coming back to court. And then, of course, what Jess used to do, which as a best interest fact finder or custody evaluator, they write reports, they report at court, but they might want to talk to the clinician. And that's a good way to kind of keep the clinician safe in the space where they're working with the client, whoever your client is, and be very clear on who your client is. Always, 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 if you're going to treat a kiddo, make sure you have both parents consent, or you see a court order that says one parent has the authority, either solely custody or the authority to sign the kid up for therapy without the other parent's permission. I think it can be a tricky space for a lot of therapists. We also have developed, so Jess is chairing the child law section with Stacey Fukuhara Barkley. I'm on the board as well. And we've developed safe harbor language for therapists to put in their agreements so that the courts have said, look, if we need the therapist to testify and someone subpoenas them, we can't absolutely protect them. But if you guys put this language in that basically says the therapy is meant to heal the family, the clinician is not to be subpoenaed and not to have to testify or give over their notes to the court. If we need that information to get into court, we can bring in the forensic, the best interest fact finder, custody evaluator, guardian ad litem, or parenting coordinator. They can talk to the clinician, then they can write a report. But we're not going to put the clinician in that situation. And so I think a lot of well-meaning mental health professionals pick up the phone. It's mom's attorney. She wants to talk about the case. You tell them some things. That attorney is going to put it in a declaration or an affidavit, and now you're going to be subpoenaed because they can't get that evidence in without you physically there. So just be careful. You can always call us. We help people all the time kind of navigate these situations. Okay, I'll go faster. Clarity regarding role. We talked about that. Obviously, therapists, you guys have good boundaries. The AFCC, the Association of Family and Conciliation Courts, actually has guidelines for mental health practitioners working with court-involved families. And I can send that to you if you want it. And it also says that mental health practitioners should not be making recommendations about custody. And I know that can be really tricky because especially if you're treating the kid and the kid is saying, yeah, I really don't like Fridays at dad's. I wish I could spend the time at mom's. But be careful because clinicians are not supposed to make recommendations about specific time sharing custody. So the schedule or, so just be careful. It's so hard for you guys because you can't bill insurance for all these side conversations with the forensics or the mom's attorney or dad's attorney. And so we really do encourage using a team where everybody sort of knows what their role is. And I think that can be very, very helpful. We actually have, I'll bring it up at the end, but we have a chart that talks about the different roles and helps you understand it a little bit better if you are working with these families. And then as far as, courts will often order people into therapy, even though therapy, much like mediation, works better when it's voluntary, but the courts are heavy-handed in the order. So my feeling is we should be letting you guys take the driver's seat as far as assessing the family for what they need. But unfortunately, oftentimes we will have a court say, co-parent counseling, and they'll even put your name in the order, even though you didn't agree to take the case. So sorry about that. But I think the better process would be to hand it off to the mental health professional, let them do their assessment. And sometimes we need multiple therapists. Sometimes we need a child-focused therapist just for the kid, safe space to help the child with coping tools. But, maybe we need a family therapist to talk to everybody and manage if there's parent-child contact problems. Sometimes parents can't communicate with one another. Kids are well-meaning, but oftentimes, they love both parents. They tell two parents different things, and then the parents go to court over that. And that's really, really hard. So we don't want to make things worse for families. We want to try to make it better. Am I still doing this one? No, you're doing alternate. No.
Yes, I think I got this one. Yes, yes. So we want, when possible, to keep families out of the court system, right? We don't want a stranger, a judge, making these decisions for you. If we can empower the family, we want that to happen. And there's many ways that can work. It doesn't have to always be mediation, right? It can be quite amicable if the parties communicate directly. I have to remind myself, many people don't find their way to mediation or litigation because they've solved the problem themselves. They've just worked together. We call it, sitting at the kitchen table, and they've come up with a plan. They have, co-parented peacefully, and they never need our services. So those people are out there doing a good job at what they can handle together. Then there are those who need a little bit of assistance, but maybe not formal. They'll look for the guidance of a friend or an elder in their community. Maybe that's a therapist, a pastor, someone who has, some knowledge of their family and can give them advice and guidance through a transitional time. Now, if you need more help than that, of course, now we're moving towards maybe a little bit more professional custody experts. A custody evaluator is someone who has a PhD or mental health background who's going to provide recommendations and do a report. A best interest fact finder is typically a lawyer who does an analysis and home visits, but from the legal perspective, maybe based on that statute, the best interest of the child factors. So we could ask for recommendations from some professional like that. Then if, that doesn't lead to, perfect resolution, we engage mediation and we use a neutral facilitator to guide the conversation, find common ground, help them focus on the needs of their family. And then as it, escalates from there, if that, of course, court is there if you need it, but here's the sliding scale, right? Here's where it starts all the way down here in the green is low conflict. They're working it out themselves. All the way in the red at the other end of this spectrum is court, right? This is where they have lawyers now, they are adversaries to one another, and how much that has escalated, right, from the direct communication. Now there's almost no direct communication. They're not making decisions together. They've lost control over the process. It's very expensive. That's the other downside to this, right? It really depletes family resources. So I think this chart is so beautiful to see the options available to families. And mediation is down here in the lower cost, lower conflict zone. We're supporting families hopefully before it escalates, but often it has escalated and we can de-escalate back down. But we want to keep families in that green zone of collaborative decision making. And sometimes that requires a little guidance, and that's really what we're there for. And another reminder too is this can work in parallel with family counseling or co-parenting classes or individual therapy. So because it's a very highly emotional area of practice that we do, we also absolutely want the family to be getting support along the way. But these are the decision-making legal parts of the process and how they can fall on this scale.
Okay, and I'll pipe in there, but because I also think, I mean, just like if you have a friend or family or a client struggling with this, first thing is get them a therapist so they can manage all the emotions, the shame, the sadness, the disappointment. I mean, divorce is a life transition, and it's an adjustment disorder. It's hard. The other thing is have them go see a financial planner. That doesn't cost that much money, and you're not hiring a lawyer. The problem with hiring a lawyer is once you give them the $10,000 deposit most of them ask for, they're going to spend it however they want. And it might not get you divorced, right? And so you just got to be realistic about a lot of these. More and more people are coming to us saying, we've heard of mediation. We don't really understand how it works. We're still fighting. We're not getting along. This isn't a kitchen table divorce. We want your help with the paperwork. We need to do all the forms that the family court expects you to get through to get that divorce granted and stamped. But we try to guide people through it in ways that are not as expensive, that they stay in the driving seat, right? They get to decide, yes, I can live with this. No, I can't. No one is going to impose anything on them in mediation. In some ways, that's kind of the failure of mediation because we don't have the power to order people to do things, right? We're powerless. I mean, everybody's like, oh, you're the mediator. You can do it. It's no, I have to work with what they want at the end of the day. Mediation can be informal. It can be, there's no rules of evidence. Just tell me what you care about. Help me understand what is the most important thing to you in this. And I will try to work with the other side to facilitate a negotiation and get an agreement that makes sense for everybody. It's a lot faster than court. I mean, I think people always misunderstand how long it takes for a judge to make a decision. Divorces that go to trial can take years, like 6 years. We've had cases where kids have aged out during the divorce process, and they can cost hundreds of thousands of dollars, and nobody wants that. Mediation is also a flexible process, right? So we can decide, can we all meet together? Is that something that's viable here? Or do we need separate sessions? Or maybe we start together, but then we break out into separate sessions. Our job is to facilitate communication and understand not just what people want, but why they want it. So then we can get creative, right? Because there's rules at court. Property division is based on a partnership model of property that the Hawaii court, has used. It's comes out of case law. Essentially, you get a credit for whatever you brought into the relationship. So it's your capital contribution. But if it appreciates during the marriage, that's half the other person's. The same is true for gifts or inheritances that are received during the marriage that still exist in the marital estate today. Now, that's a tricky one, and I can get into the weeds on property division. And alimony is not formulaic either. It's based on factors. So they're looking at the age of the parties, the duration of the marriage, the ability of each party to earn on their own, all these different factors that are laid out in the statute. But different people are going to apply them in different ways, right? And so that's where it gets complicated. It's not like California where they have the disamaster and you could it spits you out a number of what alimony should be, right? We don't have that. And so it is complicated. And because of that, I think it's really, really good for families once they're educated and they understand what their rights and responsibilities are to make decisions for themselves based on their own values. Mediation obviously is confidential, right? It's confidential from the courts pursuant to the rules of evidence. Rule 408 says, offers of settlement cannot be later introduced and then used against people. But it's also confidential in the sense, a lot of our cases, there's 2 lawyers and 2 parties. Some of them are pro se, meaning they don't have lawyers. Sometimes one side has a lawyer and the other doesn't. But if we talk to each of them in separate session, and if there's anything they don't want us to tell the other party, we can honor that. So it's really meant to be a safe space to talk about what makes sense. Everybody's always afraid, well, if I agree to this, but then we don't settle, are they going to use that against me? And the answer in mediation is no. It's a voluntary process throughout. They can stop at any time. If they don't like their mediator, or they don't feel safe, or they feel like they're getting bad information, they can stop. We refund people. So we work on a deposit basis. I wish we could use health insurance dollars. And I think someday maybe we could for parenting plan mediations, if any of you folks were interested in doing that. But that's my pipe dream. But for now, we're private pay. But if people want to stop the process, we stop and we refund them. Again, the goal is to get a mutually satisfactory settlement that everybody can live with. And that, I think, is one of the most compelling tenets of mediation is self-determination. I think I'm still doing this one, right? Again, it's a flexible process. We can meet with you jointly, separately, on Zoom, in person. I always tell people my job is to help you make a good decision. So you need to tell me when you feel safe and comfortable, because that's how you'll make good decisions. If you want to be on your couch in your jammies drinking tea on Zoom, let's do that. If you want to come into our office, we have a conference room. I will put shoes on and we can meet face to face. If you need to have other safe people there with you, whether it's a lawyer or your best friend or even, your therapist, if they're willing to do it, we can be flexible in the process to try to help people be in a space where they understand all of the moving pieces and can make good decisions. I think this is still me. So again, we can be flexible in how the sessions are structured, who's included in the sessions. We do a lot. 2020 changed everything. I'm on Zoom probably more than half the time now in mediation. There's been a lot written, and I used to teach a course actually with David Chandler, who has since passed away, but he was a wonderful mentor of mine, great mediator, and he was a sociologist by training. But, there's all the evidence, there's styles of mediation, right? A facilitative mediator is just like, well, what do you want? What do you want? And helping people communicate. Evaluative is more of the legal side. Like, well, if you go to court, here's what's likely to happen. Here's what the law says. And this is, I think, can be helpful in people understanding what their alternatives are so they can make good decisions. Narrative is all about storytelling and how when people feel heard and understood, right, then it's easier for them to get to a place where they can make good decisions. And then, of course, there's transformational mediation, which is amazing when it happens. And I've seen it happen where you start out with an order for protection, a temporary restraining order has been placed on mom. She can only see the kids at supervised visits at PACS. And by the end of mediation, they're talking about how they've dropped the TRO and they want to share Christmas, and they're talking about how to do open presents together. And it's the most wonderful thing when it happens. My feeling on the styles of mediation is there's not one perfect way. You need them all because these are hard cases and these are difficult situations. Again, in mediation, you just say what you think. There's no rules of evidence. Nobody's objecting. They can have lawyers, but they don't have to have lawyers. They can start out saying, well, we just want to mediate custody or time sharing or decision making. And then, as they see, okay, wait, this process actually works. Maybe they want to do property division and spousal support. And again, remember, in mediation, our child support guidelines now allow people to agree on different amounts of child support. If you're going to go to court, the judge is going to run the numbers based on the guideline, and whatever that number spit out is going to get ordered. So you lose that flexibility to try to be creative. And then, of course, we schedule, we're usually about a week out. If you want to come into mediation, we can get people seen very quickly. We can also recommend good attorneys that we work with all the time, that we trust, that we think do a good job, that aren't just going to, come in there and burn everything down. So, we do free consultation. So we're happy to talk to anybody about what the specifics are to their situation and try to see if mediation is a good fit for that particular family. It's not the right, mediation is not perfect. So we're not going to be the silver bullet for every family, but I do think, with many of the families, it's good. Like Jess said, start on the lower green side, start at the kitchen table, move up to mediation, get a therapist. Don't go straight to like litigation without trying other things. Okay. This is probably a good time to take questions, I think, if you guys want, because we've been talking for a while. Unless, Jess, you want to add anything?
No, I think you covered it. We'd be happy to take questions from the audience or feedback or, thoughts. These are the areas of our practice. So this is, what we do. But yeah, I'm curious as to everyone's thoughts, reactions, questions.
Oh, I got to speak slower. Sorry, I know. Time is money. I bill hourly. You can tell, right? I will talk more slowly.
No, thanks. Thank you, Katie. Thank you, Jessica. Yeah, there's no way for our key presenters to keep up with everything. I know that they're doing the best that they can. Again, one of the limitations of this format. Katie and Jessica, if you could, there are two questions in the Q&A part. I'm wondering maybe if we could start there. So on the very bottom of the interface,
Oh, how much
Zoom
is
Q&A,
mediation?
kind of to the right of the green share arrow.
Yes.
If you click on that,
Yes.
would it be okay if you two tag
I
team
can take
those
how much is
questions?
mediation if you talk about kids first.
Sure, of course.
Okay. Hi,
Okay.
Leslie. I think I know you. We were on Mental Health America Hawaii's board together a million years ago. Anyway.
Thank you for your question, Leslie. So the question is there a requirement for divorcing parents to attend classes on the impact of divorcing parents on kids in Hawaii? That's a great question. Yes, there is. It's a one-time class, not series of classes, but that program is called Kids First. And it is implemented at least on Oahu. They have a location in Kapolei. They have a location in Honolulu. They run it, I believe, every certain day of the week. But what they do during that class is they have children of elementary age up through high school also attend with their families. And so the kids go to their age group. The parents go to the parents group, and they get a little information about how to handle this big change in their family. Maybe remind the parents of some best practices so that the kids maybe don't feel so caught in the middle. The kids get to go to their own room, I believe, and Katie can correct me if I speak out of turn here. Believe they write a letter to their parents about their experience or maybe something they want them to know. I believe they also sometimes get to like wear a little robe and gavel to maybe feel powerful or a little like they have some voice in this. So another part of the process for kids at least is to know they're not alone. They're in a room with a lot of other people going through the same experience. Sometimes teens gripe about it. They're not thrilled to be forced to go to a program, but I think that it's really beneficial for them to see that other, kids their age are experiencing the same thing. But yes, it is basically a resource, one-time education for the parents on the impact of divorce on kids and how to mitigate that, address it, care for the kids. Yes, Absolutely. That's
And
and
I
so
can
that
add on to that because I actually had lunch with Stephanie Resents today too, she started Kids First on Oahu with Lori Tochiki and other folks, June Ching, many of you know. I think his name was Dick Kappenberg. I talked to Craig Robinson sometimes, some of these old time practitioners who've been working with kids and families. And the way it used to work was you would have a mental health professional and a judge talk to the parents about the impact that their fighting could have on their kids. And then the kids would split off. I actually used to volunteer for Kids First when I was still in law school, long time ago. And so it was based on age. So for the older teens, you do different activities versus the younger ones where maybe they more like dressing up in the robe and the gavel. But it's now also supposed to be, so you cannot get divorced without attending Kids First in the state of Hawaii. They check and make sure. It's also supposed to happen for all of the parentage. So people who have never been married but have children together and are in court fighting over custody and support, maybe not fighting, but they're in court, they are also supposed to attend a Kids First session. Historically, it hasn't always happened. I think they're trying to be better about implementing. On the mediation costs, so it's an hourly fee. We usually ask for a deposit. Depending on who your mediator is, it can range from is it 325 to 425 an hour? So it's not cheap. We were doing sort of a one-time 3-hour flat fee mediation to just help people who are really low conflict get their, foot in the door and get, if they think they have a deal and they just need this, because we also assist people we facilitate the filing of their uncontested divorce documents, right? And so we can do that through the paralegal or the legal assistant at $100 an hour fee. But it's not cheap. And this is why we're always trying to come up with other ways to do this, because obviously litigation is not expensive, but private mediation is not free either. And for a lot of families, we like to say, oh, we can get you divorced for about $3,000 to $5,000. It depends. If people are really low conflict, they'll come in below their deposit and we refund the money that they don't use. But if people keep fighting, then we're going to ask for another deposit. So it really does depend. I wish people, yeah, if people are like, we won't fight, we promise. I'm like, okay, we'll make it cheap. But if you're going to fight, it's going to cost money. Does that answer the question? And we can also send if you want. We have our whole materials on all of this. We've got our agreements to mediate and all of our, after we do a
yeah,
free
one of the
consultation,
most
we have an outro document that goes to clients so they can see a summary of what mediation is and the fees. So I could
Yeah, it's one of the most common questions in the consultation. How much does it cost? And it's an impossible question to answer because it's hourly, right? So that if it's in and out, yes, we can be very quick and affordable. If it's a drawn out process that needs a lot of support, then it takes longer and costs more. Yeah.
I'm going to let you answer the one on court-ordered custody evaluations.
Oh yeah, of course.
Does that
Okay,
sound okay?
let's go to that one. Dina or Diana has asked if we find ourselves as therapists being asked to participate in a court-ordered custody evaluation or litigation, do you allow therapists to contact you for guidance on how to respond? How do we find out about this as an option for our own best response to these circumstances? The hardest part is the fear of not knowing how best to respond in the best way when the law becomes the compass. Great question. That's when it gets muddy, right? What your role is, who is your client. So hopefully we're protecting therapy from court, like when you are subpoenaed or asked to testify. That's what that safe harbor language is meant to do. And so sometimes at the outset of therapy, you can try to create a bubble around your practice with the client so that the law doesn't stampede over your process. But let's say that does happen to you. You are obligated, of course, to respond to legal subpoenas and things like that. So unfortunately, we can't tell you otherwise. But yes, you could always contact, I think, someone in this space to find out the best way to respond. We do work with people who do this. So yes, I think getting guidance is a good idea. I think it's really going to be about protecting confidentiality with your client and prioritizing, like Katie was saying, the clinical side versus being a forensic tool, right? Because what happens sometimes is it can be weaponized or kind of tainted by the court system, and then your process is interrupted, your trust is with the client is broken, and That's really hard. And like Katie said earlier in that case, PO versus JS, which I think was 2016, 17.
Sounds right.
That's the one where there is a little bit of guidance about when a therapist can testify or not. If it is a child therapist, do they allow the child essentially, do the parents, are they allowed to waive the privilege and have the child's therapist testify? It's a little bit more muddy maybe if you are the family therapist or individual therapist in some other capacity for a member of the family. I don't know if I'm asking or answering the question very well, but that is a hard part of what you
I will
do.
add too, like if you want to call our office, I'm happy to chat with anybody who just has questions. There's a very small group of people that work in custody evaluation and best interest fact finding in the state of Hawaii. The family court actually maintains a list on the on the judiciary's website of all the mental health professionals who do custody evaluations and are certified to do them. And then we know all the people that do BIF work, so we can help you. And one of the questions you're going to want to ask is, what are you going to put in your report? Are you going to quote me? Like, am I going to be quoting my child client and put that kid at risk now? So again, I'm happy to talk with anybody because I know a lot of these are very specific about a particular case. Another
When I
question.
was working as a BIF, I would often say, you can kind of share with me the flavor without being quoted in quotes so that, like give me the information that's helpful for the custody evaluation or the report without hopefully like tainting or putting yourself at like some liability or so yes, we would try very best to walk that line of like benefiting the family with information, benefiting the court with information, but not ruining the whole process and confidentiality.
Okay, other question is, I had a parent who was absent for 3 years but wants to be a part of their child's life. Where do I direct him to for support? And these are such hard situations. And I know for the judges, especially, I used to get a lot of guardianship adoption mediations, mostly because it was an absent parent who showed back up, especially in a legal guardianship case. Usually grandma was, the legal guardian and had been for years. Kid was, older now, had not seen this parent, but under the law, parents have constitutionally protected rights to raise their kids. So regardless of what's in the best interest of the child, right now we're not talking mom versus dad or dad versus dad or parent versus parent. We're talking about legal guardians who don't have a constitutionally protected right to raise this kid and a biological legal parent who does. So the courts was in the mediation because they want me to come up with a plan. It takes a village, right? And we can work out a schedule. Let's all be involved in a way that doesn't freak this kid out. But if it goes to court, law says dad's going to get the kid, right? And a lot of these were like mom had passed away. Dad had been MIA for a long time. So maternal grandma had been raising this kid forever. And now a parent shows up, has no relationship with the child. And obviously that's not, a safe. So what I would, my preference would be, and you guys are the mental health professionals, so maybe I should defer to you, but let's start slow. It depends on the child's age and developmental capacity, right? But you start with maybe therapeutic visits. If the child has a therapist, dad can come to those. Dad could write a letter. I'm assuming it's dad. Is it dad? It could be mom. Oh, it says him. You could start with a letter. I mean, I would let the mental health clinician who's working with the child kind of, while you don't get to give recommendations on custody, I think you can help tailor sort of a transition plan that re-engages and repairs the relationship in a way where the child feels safe. And it's going to have to go slowly, right? It's not going to be on the parent's timeline of, I want to see my kid and I have a right to see my kid. Now, this is, of course, a child-focused, that might not be what the law does. If he was going to hire a lawyer and file a motion for custody and visitation, I can't say that a court is going to take that sort of slow, child developmentally appropriate approach. I mean, I would encourage him to get a therapist and have someone, to help him process and figure out like what has he done and what are his choices. And there are I tell my 3 kids all the time, life has choices, choices have consequences, and we all need to take responsibility for the choices that we make. But if he wants to repair and he genuinely it's probably going to be, unless there's safety issues, a good thing for a child to have some meaningful relationship with this parent. And so how can we make that happen in a developmentally appropriate way and probably keep them out of court? Because if they go to court, again, the law is going to prevail and parents have rights, even if they haven't shown up as parents, even if they haven't changed a single diaper or brushed a tooth or, taken them to the doctor at all. Their constitutionally protected rights are there unless they've been terminated under what your revised statute 587A.
Yeah, I think you explore the reasons for the absence, you assess if reunification is appropriate, and then you get the support team in place to guide the, child-centered, introduction to that process. We like using that term step up parenting
Mhm.
time, right? So it's not overnight changes on children. It's gradual. It's a step up that gives time for adjustment between stages. So that would be my brief 2 cents too.
We have a couple other slides if there's no more questions, or if there are questions, happy to answer.
Oh, and I think Susan too. I think there's a portion Andrea is
Oh
going
yeah, Susan.
to.
Yes. Yes, sorry. We will, okay, we have just one more quick question, and then after we'll have you folks, if it's okay, we'll have you folks finish out your slides, and then we'll have Susan, Brad will give Susan a quick introduction. Susan will share her lovely, lovely thoughts, and then we will take some more questions. How does that sound?
Perfect.
Okay, so one last quick question, is just, would you, Katie and Jessica, feel comfortable to share, for me to share the slides with folks after the
Oh,
presentation?
yeah, no problem.
Okay, lovely. Thank you so much.
I don't think we have a ton left. Let's see. Oh, how do we know mediation works? There has been research, we're settling cases, I think around 75, 85% of the time, which is really nice. I think that's a lot. Those are pretty good statistics. It doesn't mean that every case is going to settle, but it does mean that it's worth trying. Um, and then of course, I'll let you read this. We will share our slides. I want to make sure if we get a chance for Susan. This was sort of just our thank you. And then if you're interested, we have a quarterly newsletter, and we also are going to be doing more trainings. I really genuinely feel like mental health practitioners could do a better job with a lot of these families when it's just co-parenting and we're not talking about the legal issues of property division and spousal support. I think it's crazily expensive that these families have to go to court and hire lawyers to fight about whether they get Saturdays and alternating weekends with their kids, and it's not healthy. So, we're trying to do more trainings. We've got our quarterly newsletter, so feel free to connect. And oh, that's it. Okay, Susan.
Right. So I have the pleasure of introducing Susan now, and then I'll turn it over to her. So just give me a minute. So Miss Susan Bracco earned her BA in sociology from California State University, Long Beach, and an MPH from UCLA. She returned to Hawaii in 1984 with her son Jason, and soon became the first coordinator of the Special Parent Information Network, or SPIN, a parent-to-parent information and referral program within the State Department of Health and funded in partnership with the Department of Education. Through newsletters, infographics, e-blasts, a warm line, 2 websites, and an annual conference, SPIN ensures that families of children and youth with disabilities have access to information that supports informed decisions about health, education, and community living. So, welcome, Susan. Thank you very much for your time. Just to kind of give folks a sense of the rest of our time. So Susan will can kind of take it where she wants from here with more questions, answers, comments, or whatever, and then probably we'll have time for more questions from the audience and or Susan and our CAMD leadership. And then usually if we could save a couple of minutes at the end for a kind of bookend it with housekeeping about CEUs, announcements, and all that kind of stuff. But take it away, Susan. Thank you.
Well, I really always appreciate the chance to talk to you folks and learn from your perspectives. And I have to say that I have been a cheerleader for mediation for decades because I work, as Brad was saying, with families whose kids are receiving special education services. And one of the procedural safeguards that has been written into special education law is the ability to ask for mediation when there's conflict. Conflict is a natural thing when it comes to special education services, but also it's so interesting. I wish we could give you to every family, but the reality is that many families receiving special education services can't afford the kind of mediation we're talking about. Fortunately, special ed mediation is free to both schools and families. But as a parent answering the phone and talking to many, many parents, I know that statistics are mixed about whether disability tends to create more conflict in a marriage and more divorce rates. At the time that I got divorced, back when I came back to Hawaii, I was fleeing an unhappy marriage and coming back to my parents here in Hawaii. And at the time, we did have higher divorce rates if you had a kiddo with a significant disability. And one thing I've noticed talking to families is often when a child has significant needs, and folks in the evidence-based community know all about kids with conduct disorders and kids with attention deficit disorders, nonverbal kids like my kiddo, kids with autism and eccentric behaviors. Often the mom tends to get the brunt of the caregiving and the advocacy in speaking up for that child, either at the doctor's office or in the school setting. And because of that comfort level of having dealt with the child's problems, they often feel more confident that they can meet their child's needs and that the husband cannot. And husbands tend to think differently about the disability issue. What I have found with families, and I'm not an expert, but this is something that many other parents also see, is that when a mom is worried about her kiddo's future, she wants to go to the worst case scenario and work backwards from there so that she has plan A, plan B, plan C, all the way down to Z. Dads don't want to be that negative. They're saying, oh, there's nothing wrong with him. He's fine. You're just coddling him, etc. So there are some disability issues that also get into the mix with your conflict that you're dealing with. And I'm hoping, and I know I've been to court for my divorce and also for guardianship, and the judges I spoke to were very caring, but you would hope that the folks in the court system understood that dynamic, because it can be very, very stressful. If any of you have nephews or nieces with ADHD, you know how tiring that can be. But the advantage of going to the conflict early and trying to maintain the relationship is golden. And that's why what you're doing is so important, and what special education mediation does is so important. And what we have found about the benefits of it is that it keeps the focus on the child, because that's what you want. It's about them. It fosters more creative solutions. You were talking about that, because once you go to a judge and they say this is my decision, or in the special education arena, if you go to due process and a hearing officer makes a decision, it's written down very strictly and you have to follow that rule. And the control gets out of the hands of the parties and into the decision maker, which is unfortunate many times. And at that point, you have enemies often between one side and the other. But mediation can provide the creative solution. It can reduce the risk of having it escalate into a really ugly battle, as you said. And it helps build trust sometimes. When people are unhappy in their marriage, or they're unhappy with a school situation, it gets to be all consuming and you think it's all bad. But when you get to talk to a mediator, you recognize there are some things that we have in common that are working, and let's just promote those things. But the things that we really are having trouble with, that's what we need help in mediating. So I applaud what you're doing, and I hope other people can point families towards you, because it's so much better than having two attorneys building up the conflict and the drama and ending up with really harsh feelings on the other end. Thanks.
Thank you so much for your perspective,
Thank
Susan,
yeah.
and for what you do, because it's so, so important. And I feel like, unfortunately, there are just, when kids have significant disabilities, or there's just more for parents to fight over sometimes, right? I mean, we get, one says, oh, there's nothing wrong with that. And the other one's like, no, we have diagnoses. We have this whole assessment that's been done. Like, what do you mean there's nothing wrong? And so, while we do want both parents to be meaningfully involved in those cases, I think there are more reasons why judges, or even, families might decide, hey, we need a point person for this, because these decisions need to be made quickly and we need to get these resources, and they're not going to be available forever. You can't just hem and haw and take 3 weeks to do your research because you don't like what I said. And you're right, there oftentimes is one parent who is more on point, has been doing it longer, understands, the providers and but it's hard once the lawyers get involved because they will twist things. They will make people look like they are shutting the other one out or, independently making decisions without consulting the other parent, all of the things. And so it can be what comes out at court. And I've seen this with friends who've gone through this. I've seen custody evaluations for people where I watch them raise their kids. The professionals get it wrong sometimes. And do you really want to risk your family's outcome for someone who's going to spend an hour with you, an hour with your ex, maybe see the kid for 3 hours and then write a report? I don't know. Um,
This area is so subjective, right? Both parents might care deeply about their child. The common ground is they love that kid very, very much, but their perspective on what's best for them might be very different. Like you said, one might see, they need this support. One side might say that's not necessary at all, or I think they should go to this school, or I think that they should go to this school. That's hard in any family, let alone if communication is broken or you're not trusting the perspective of the other parent. That does exacerbate things. And yeah, having a child with extra needs or just, special circumstances puts a lot of pressure on the parents to feel like they have to get it right. And, you don't want that. And so hopefully mediation is a safe space to consider both sides, maybe get better understanding of why one parent feels a certain way. I think it's also important to remember that following a divorce or, a two household family, from one, there's going to be a learning curve for the parent who maybe wasn't primary initially. Maybe mom, we gave that example, took the lead on the doctor's appointments, the parent teacher conferences, the appointments all along the way and knows more and feels stronger. And dad has to catch up. Or maybe it's the other way around, right? But whatever the parent was that was the leader for that sphere of caregiving, has to maybe like allow that other parent to try to catch up and also carry some of that weight with them. Or it's a division of labor that works and then you work around it. But there's so many, ways it could escalate and cause tension, and hopefully mediation finds common ground in caring for the kids.
Well, and I can add that in working with these families, one of the things that we found has worked really well is to sort of have co-parenting safeguards, right? And if you're going to say, here's our pediatrician, here's our dentist, follow and be guided by the experts, whether it's the person who did the psychoeducational assessment or whoever is making recommendations. It can be hard. Well, if parents are fighting, right? If one says, well, I think this, and the other saying, well, I don't want that, and they're fighting each other, but really this is about the kiddo, right? And what are the experts saying? What are the people that you trust, that you hired to service your kid? And so we can also build in, taking guidance from the professionals who work in the field. We can build in semi-annual parent meetings, which sometimes can be really, really valuable just to get on the same page where both parents are prepared, right? Because it doesn't always go well where if you're to pick up or drop off, you're like, hey, I want to do this summer program at the YMCA. What do you think? And the other parent's like, well, I haven't looked into it. How much does it cost? What's the schedule? Where is it? Is it near my house? And then all of a sudden it's a fight, right? Whereas if you're ready for these conversations and we have them planned out, you don't have to have a mediator there. You can do it yourselves. And so we do try to give parents some of these tools that we've seen work for other families and try to help them do this on their own. Other questions or comments?
I was trying to hold back and let other people ask questions, but I think sometimes what we face as clinicians is we'll have parents seeking support for their kid and the other parent saying, no, they don't need it. I don't believe in mental health, or a parent seeking support and with unknown to the therapist with the intention of trying to drag the other person under the bus in front of court and then kind of like saying, oh, well, we want you to submit a summary of the things that the kid told you in court. And so we have those situations occasionally come up. I don't really know what my question is, but
no, but that's there are lawyers out there. If their client comes to them and says, my kid doesn't want to go see her dad, they'll say, take the kid to the therapist, have the kid tell the therapist everything.
Right.
And then we'll subpoena the therapist. And you don't know you're stepping into that, right? No one's telling you this is like all part of this bigger scheme.
Right. The presentation is, oh, they're dealing with trauma as a result of abuse. And then, and then it comes to pass that you learn, oh, it's the dad, it wasn't me, and it ends up being kind of this custody thing. And um, I don't know that right now we have a requirement to have both parents agree to treatment for those reasons, where sometimes the parent will say, no, I don't believe in mental health. I don't agree to this. But maybe that could keep us out of some of these stickier situations. I think we do try to get it, but in those situations, you want to provide mental health treatment to the kid if they need it and they want it. So it kind of makes it a little bit more challenging.
You
Um,
hope that the best interest fact finder or the guardian ad litem recommends it. Maybe that's one step. And then the best practice is actually to have both parents take the child to the sessions, right? So that they're participating, supporting. That's not always happening. That
right.
is often not happening. But when it can happen, that's the best chance of it succeeding, maybe without one parent putting the brakes on or feeling left out of the process or doesn't believe in the process. That's so hard. That puts you as clinicians in a very difficult
Yeah.
position to essentially be tricked
Right.
or
You're
use
used,
it as a
you're
weapon.
being weaponized.
Yes.
Yeah.
And you
And
know it.
so,
And that's why
yeah,
so many of you won't work with our families.
You know,
yeah. And
well,
that's
a
why
lot of times
now,
people don't, right? They're like, I don't want
yeah,
to touch that.
I'm much more aware of it. And so, when I'm supervising or those kinds of things, I will let them know, hey, if you're doing an evaluation, remember to always put in was reported by so and so. So and so said this. You are not making any sort of judgments. You're just reporting, like stating the facts about what happened and just being careful with documentation. But I'm always a little bit more wary in these kind of divorce cases, especially when one starts accusing the other parent of doing all
Well,
this.
and you're a mandated reporter, right? So
Right,
then what do you do with that? And if you don't actually
right.
believe it, but it's been reported,
We don't have any choice. Yeah, we
yeah,
have
and
to
they do that on
report it.
purpose. They're
Yeah,
told by their lawyers to go and do that. And this is where we have this. There's a very well-defined mental health. The social science is so far ahead of the law on all this stuff. But then we have the legal
right.
base where everybody thinks they know everything and they're so smart and we're going to take this to court. And they're just we need to talk because we're not helping families.
Yeah, yeah. And it makes it does get really ugly sometimes. And it's hard because you want to provide treatment, but then the parent's not going to trust you because you had to call CWS and but you don't have a choice. So yeah, it does get complicated, but I think that's where proper documentation just comes in so that you can provide the best support as possible.
Well, and I think everyone should stay in their own lane. We're like lawyers who wish we were mental health practitioners, but there's a lot of, you get some people, you learn enough about like the forensic side of things, and then it gets really dangerous because, I mean, I just think working in teams is a really nice way to do it because these are really difficult cases. Jess and I have been exploring more and more about like child inclusive mediation or child informed mediation. And, because parents do want, especially when the kid wants to stay with them all the time,
Right.
their kid's voice is heard, and that's not always a bad thing. But I've seen kiddos who want to stay at dad's house because he lets them play video games till 3 in the morning, or they
Yeah.
want to go. It's not always good parenting. So like
Right.
we gotta, and every family is so different. And so it's like the more I do this, the more I realize like, oh gosh, I
Yeah.
don't know a lot.
Yeah. I
And the
think we
ones that
all
are super high conflict are the ones that need therapy the most. The
right.
ones that are super high conflict are also the ones maybe most likely to abuse it because they're high conflict and in litigation and getting bad advice about the process. And yes, exactly. The exact reasons that maybe a clinician would not want that case are exactly why they need someone on that case. But
Yeah.
how to protect the roles is something we're very passionate about. Katie did include that chart about, best practices about how to keep them separate and protected. We're trying very hard. Child law section had this training where we're trying really hard to tell lawyers to stay in their lane, encouraging mental health professionals to take these cases and protect their role from crossing that, into the messiness. So yeah, I think that there's reasonable fear
Yeah.
there.
Yeah, and I think what we've also found, like when the lawyers get involved and when the judges get involved, it takes away a lot of your choices. So we try whenever possible to work it out without all of that going on. Sometimes it's beyond our control, but We are learning to play better in the sandbox with everybody, so it doesn't get to that level, but it can be difficult. Oh, sorry, I'm seeing the time flag. We're in time. I'll stop talking. I could keep going.
No,
This is
thank
such
you all
a
so much for your
fascinating topic.
questions and for the work that you do, because it's so, so important. We're here. This is hopefully the beginning of a conversation. Feel free to reach out to us. I think our contact info is all on the PowerPoint slides. And yeah, I appreciate the opportunity.
Thank you. So maybe I'll bring it to a close. You can kind of tell it's always a good time when the time flies by. Selfishly, I can squeeze in one more question before I do a closer. On your slide about the cost conflict process ranging from the kitchen table to court, that's such a wonderful slide. Just the question is, what once you're at a higher level, like once you've gone up, is it possible to go
You
back
can come
down?
back. Yes.
Yes,
Okay, so that sounds like it might even be a goal to go back
The
down.
rules of family
absolutely.
court say that before you're allowed to file a motion to set the case for trial, you have to show that you've at least attempted mediation unless there's been domestic violence and you cannot, and mediation's not
I
appropriate in the
see.
case. So I've gotten cases where they're set for trial. They've got their trial dates and they send them back to mediation. And I'm thinking, oh my goodness, why would the judge send this? It's already, they've gone to MCP, they've done, and it settled in 2 different sessions. It was one with mom, one with dad, and it was done. But they'd also been through the ringer and they were out of money and they just needed to be done. But no, they can come back down at any point in time. The courts will mandate mediation unless there's reasons not to. So oftentimes we'll say, hey, try it in the beginning, because then at least you can say, look, we tried
I
mediation. A lot of
see.
people come in and they just don't think that they've tried to talk to their ex and it's just not happening, but they can always come back. Kitchen table, I've actually seen people settle their own divorces once they get sick of the lawyers and the mediators and they just go back to kitchen table and they're
Yeah,
like,
I was just gonna say sometimes court isn't what you think it's gonna be, right?
mhm.
You might be pretty far in the litigation process and realize how slow and expensive and high conflict it is, become disillusioned with this idea that you're gonna have your day in court and then find your way back to a lower conflict zone like mediation. So
Oh,
yes, you can
thank you.
absolutely always de-escalate.
Oh, thank you. Okay.
It's
Thank you
never
so
to
much.
get to go in front of the judge and tell your whole story and then
Oh,
the
right.
dramatic music and
Like this grand moment. Yeah.
Right, yeah, but I think some people think that that's going to happen. They get to go to court and tell the judge their whole story, and the judge will totally believe me
Yeah,
and side with me. But that's not usually how it
See.
works. So,
Well,
exactly.
bringing us to a close, for CEUs as a friendly reminder, whichever email you use to register for today's roundtable, please be on the lookout for a feedback survey we'll be sending to that email address. We're appreciative of all feedback, regardless of whether or not you applied for CEUs. Would also like to thank the HPA and the Hawaii Behavioral Health Connection who are co-sponsoring this roundtable and offering free credits for its HPA members. As a friendly reminder, you'll be expected to attend at least 90% of the roundtable to get credits. And a special thank you again, round of applause for our presenters, Susan, Candy Leadership, Kurt, Jamie, Scott. Thank you, everybody.